Hi everyone, welcome back to Let's Talk Legal with Karimi Chege. My name is Ashley Karimi Chege, an advocate of the High Court of Kenya and your go-to employment expert. This is Season 1, Episode 3 of Employment Law Unlocked, where we'll be talking about the second benefit under the Employment Act, being maternity leave. So what are the objectives of today's episode? 1 is to outline what the law provides in regards to maternity leave. 2, what are the conditions that must be met by an employee before they proceed on maternity leave? 3, can maternity leave be extended? 4th, are employees who experience the unfortunate incidents of stillbirth entitled to maternity leave? And 5, are adoptive parents entitled to maternity leave? So let's get straight into the episode. Now let us talk about what the law provides in regards to maternity leave. Section 29(1) of the Employment Act provides that a female employee is entitled to 3 months maternity leave with full pay. Further, the law provides that once you have exhausted your maternity leave, when you're coming back to work, you should come back to the job that you initially had before proceeding on maternity leave. Or the employer should provide you with a suitable job with the same terms like the job that you had before proceeding on maternity leave. This law seeks to protect an employee who had proceeded on maternity leave from demotion once they resume after maternity leave. So when does the right to maternity leave vest upon you as a female employee? The law provides that it vests upon you immediately you have been confirmed to your employment. The law even provides that a female employee who's on probation is entitled to maternity leave, and we shall say that later on. So maternity leave as a right does not have a waiting period. I know that from episode 1, we talked about sick leave. Among the conditions for sick leave is that an employee should have worked for his employer for a consecutive period of 2 months to qualify for sick leave. Now for maternity leave, it vests upon you as a female employee immediately. Therefore, there is no problem if you conceive immediately after your conferment. There is no problem if you proceed on maternity leave a week after your conferment. This right vests upon you as an employee immediately. Now let us talk about how maternity leave is calculated. The law provides that you are entitled to 3 months maternity leave. But this is calculated as 90 calendar days as opposed to 90 working days. So 90 calendar days means that the 90 days are calculated inclusive of weekends and public holidays. Now let us talk about the conditions that must be met by a female employee before proceeding on maternity leave. The law provides that a female employee needs to issue the employer with a 7 days written notice of their intention to proceed on maternity leave, their due date, and the date when they expect to come back from maternity leave. The law also provides that the employee can provide this notice within a shorter duration of time than those 7 days, depending on the circumstances of their pregnancy. This is because the law is alive to the fact that there could be pregnancy-related complications that the female employee may experience that may inhibit them from issuing this notice within the 7 days duration. The law also provides that the employer is entitled to ask for a certificate of the employee's medical condition, which should have been prepared by a qualified medical practitioner or a midwife. This is just a right for the employer, and they can proceed to ask you as a female employee to avail them with that certificate. Now let us talk about whether maternity leave can be extended. Maternity leave by itself cannot be extended, but the law provides that in consultation with your employer, you can request to utilize your other leave days to extend your maternity leave. This is, you can use your annual leave, sick leave, or compassionate leave as a way of extending your maternity leave in the event that you require more time with your small infant. However, kindly note that this can only be done with the consent of your employer. Now let us talk about a very sensitive matter. Are female employees who experience stillbirth entitled to maternity leave? It is unfortunate that the Employment Act is very silent on this issue. The Employment Act under Section 29, as couched, envisions that the child will come out alive, and the 3 months provided are for bonding between the mother and the newborn. However, this is not the reality to every single pregnant woman. Therefore, there is a very serious and glaring gap in law. So that means that such an occurrence is left at the mercies of employers. Therefore, it is my plea that every employer should provide for this kind of a situation in their employee handbook or policies. You remember during our episode on sick leave, we talked about reasonable accommodation of an employee. My take would be that an employer should reasonably accommodate a grieving employee. In this case, they have gone through the childbearing process and they're grieving the death of their child. Employers need to ensure that they handle such employees with utmost sensitivity and care. My proposal is that employers should inform their employees that they are entitled to their 3 months maternity leave, and if they so wish, they can come to work earlier than the 3 months, but only when they are ready to do so. This ensures that as an employer, you have covered yourself in regards to showing compassion to such an employee, and therefore no legal battle that may be meted against you for not accommodating such an employee. However, it is my plea that the lawmakers will consider having an amendment to the Employment Act or provide for this kind of a situation in the regulations so as to ensure that there is uniformity when such incidences occur. Now let us talk about whether adoptive parents are entitled to maternity leave. Section 29A of the Employment Act provides that an employee, meaning it could be male or female, who seeks to adopt a child is entitled to 1 month's pre-adoptive leave with full pay. This leave is intended to allow the adopting parent and the child bond and start their connection as a family. So what are the conditions under law that an employee who seeks to adopt must abide to? 1, the employee should issue the employer with a 14 days notice of the intention of the adoption society to place the child in the custody of the employee. This notice should be in writing and should be accompanied with the custody agreement between the adoption society and the employee, and should also include the exit certificate. Now let us talk about the case of Jane Waweru-Mashira versus Mugo Waweru and Associates. So in this case, Jane was employed as an auditor on 15th of July 2011, and she was to receive a salary of 35,000 per month. It was a term in her contract that she was to undertake a 2-month probation period. However, on 15th of March 2011, her employment was confirmed. But Jane's work performance was below standard, and her employer proceeded to extend her probation period. While on probation, on 18th of July 2011, Jane issued her employer with a maternity leave application. Her employer proceeded to deny Jane maternity leave on the ground that she was still on probation and directed that she takes 2 months study leave instead. However, Jane did not abide by this. She proceeded on maternity leave, was admitted at Nairobi Women's Hospital on the 18th of July 2011, and gave birth to her bouncing baby on 19th of July 2011. On the other hand, the employer proceeded to terminate Jane's employment on the grounds of absconding duty and poor performance. So the court was faced with the question of establishing when exactly does the right to maternity vest on a female employee. The court found that the right to maternity leave vests on an employee immediately. Maternity leave does not have a waiting period like sick leave. The court also found that childbirth is a natural process and the childbirth in itself is unpredictable. The court also noted that it was unfortunate that the employer informed Jane to apply for study leave instead of maternity leave, and the court found that this demonstrated serious misunderstanding of what exactly the purpose of maternity leave is. Therefore, in its finding, the court found that the employer's failure to allow Jane to proceed on maternity leave was discriminatory and awarded Jane 12 months salary compensation for unfair termination. So what can we learn from this case? 1, maternity leave is a right that vests on you as a female employee immediately. There is no waiting period. Once you're employed, you are entitled to maternity leave. It also vests on you even if you are on probation. And once you have issued your employer with a notice as mandated in law, the employer cannot deny you the right to proceed on maternity leave. For employers, kindly take note that if you deny your employee the right to proceed on maternity leave, you will be deemed to have discriminated such an employee on the grounds of pregnancy and will be liable to compensate such an employee damages for unfair termination. That marks the end of episode 3 of Employment Law Unlocked, but stick around for episode 4 where we talk about discrimination on the grounds of pregnancy. You do not want to miss this. Thank you so much for watching, and thank you so much for the love and support we have seen on episode 1 and 2. May God bless you. Until next time, remember, information is power, legal knowledge is freedom.